So, let us first take a look at what constitutes or amounts to a situation of demand for dowry. So, what is the connotation of the term demand here and how exactly do we satisfy that? Now, as I mentioned earlier while discussing the definition of dowry under the Dowry Prohibition Act of 1961, dowry refers to an exchange between two parties of a property or valuable security at the time of marriage, before the time of marriage, or after the time of marriage, and this exchange is always in connection with the marriage. So, in the case of K. Prema Rao and State of Andhra Pradesh versus Yadla Srinivas Rao and another, the question was raised as to what constitutes demand for dowry. So, when we say dowry and demand for dowry, what exactly is the nexus between the two terms? So, the court had in this case very astonishingly laid down that harassment for Sridhan does not amount to dowry. Now, in this particular situation, the victim had been given some amount of property as Sridhan, or a property over which a woman has absolute ownership. The property was given to the woman by her father, and within a very short span of time after her marriage, a couple of months after her marriage, the husband kept on pestering with the woman to transfer the documents to his ownership, and the woman would not agree with it. This continued for a couple of years, after which she committed suicide out of frustration, because she couldn't tolerate the harassment that was meted out to her, both physical and emotional harassment. Surprisingly, the court held that this doesn't amount to a situation of dowry, because the Sridhan property which we were referring to is not the subject matter of dowry. Now, one requires a critical mind to be able to criticize the outcome of this judgment. Why exactly Sridhan property or harassment for Sridhan property would not amount to dowry is a question for us to reflect upon. Then the term soon before her death has always attracted our attention. So, when we say soon before, what exactly is meant by it? Is there a specific time span which would qualify as soon before, or is there no time span but we need to infer it from the circumstances of a given case? Now, I would like to bring to your notice the case of Keshav Chandra Pandey, where the accused had assaulted the woman, in this case the victim, with an iron rod. This is a case whose incidents were recorded in the year June 1989. So, the victim had been beaten with an iron rod, assaulted with an iron rod by her husband in June 1989. What follows is a very interesting set of facts. Now, after being attacked by the husband in June 1989, the woman thought that the marriage, in fact, it's not that she only thought about it, but the marriage was in shambles. So, after this, there was mediation by some elderly people in both the families, and the woman continued to stay in her house for about a year, and after which one fine day, the husband leaves the woman in the house of her parents, and there were persistent demands for dowry, which has also been established in all the courts at all the levels. And the attack was also connected with the dowry demands. However, after leaving the woman in her parents' house, a fortnight after that, she returned to the husband's house, and 2 days after returning to the husband's house, she had committed suicide. So, the question in this case was, would this situation amount to a situation of dowry death? Is it a situation of dowry death, or is it just a situation of suicide by a woman? And interestingly, the court in this case had held that this is not a situation of dowry death, because the assault was made way back in 1989. So, while that assault may have been connected with a demand for dowry, there was nothing on record to show that there have been demands of dowry after the husband, after the mediation was done, and after the woman had returned to the husband's place. And the next question, which again the court very astonishingly posed, was, if at all she was the victim of dowry, why is it that she waited for 1 year or 1.5 years to commit suicide? The suicide wasn't immediate, and therefore it cannot be said to be a case of dowry. What perplexes many people who have read the case, and what comes to my mind even and may come to your mind, is, was there any situation other than dowry which could have been or which could have triggered the death of the woman or the commission of suicide by the woman? If there was no other factor which could have triggered the death of the woman by suicide, then how is it that it's not a case of dowry death? Probably the prosecution wasn't well conducted, but the question remains a $1 million one till date. So, the term cruelty can be interpreted in the same way as it has been interpreted under section 498A, rather to the explanation given under section 498A. Now, at this point, let us then discuss another landmark case of Ram Badan Sharma versus State of Bihar, in which the court laid down that there is no exact time span which is specified for identifying what amounts to soon before the victim's death, but the link should be proximate and not remote. So, Keshav Chandra Pandey versus State again has been the same thing. It has reiterated, as we discussed in the last few minutes, that it has reiterated the point that soon before her death cannot be an elongated or prolonged period of time. In the case of Rajinder Amar Singh versus State of Haryana, it was laid down that the link between a demand for dowry and the death which follows must be established, because unless that link is established, the situation cannot amount to an offence under section 304B or an offence of dowry death. And then we have the case of Shanti versus State of Haryana, where the very important fact that section 304B and section 498A are not mutually exclusive was laid down by the court. So, when we say that the two sections are not mutually exclusive, it logically leads us to the conclusion that the term cruelty in section 304B can be interpreted in the same manner as under section 498A. Then another important thing which one must mention while discussing the concept of dowry death is that a simultaneous amendment was made in the Indian Evidence Act, wherein section 113B was inserted into the Indian Evidence Act along with the insertion of section 304B in the Indian Penal Code. The purpose of making the amendment in the Indian Evidence Act was to smoothen the trial of dowry deaths and to have a lesser burden on the prosecution to prove such a case. So, this talks about a presumption as to dowry death. So, which means that under the Indian Evidence Act, the court will presume that if a woman has died under abnormal circumstances within 7 years of marriage and there is evidence to prove that there was a demand for dowry in connection with the marriage and she was meted out cruelty because of demand for dowry, the court will presume that it is a situation of dowry death, and then the proceedings will take their shape accordingly. So, this is a variance from normal offences wherein the burden lies on the prosecution to establish a case beyond reasonable doubt. So, as to conclude, dowry death is a problem which is found uniquely in India, and the problem persists because of a social conditioning that women are inferior to men. And they are always perceived as inferior to men and are also considered to be economic burdens despite the multifarious contributions that they make in the matrimonial household. Despite their contributions to the affairs of the family, they are always considered to be a burden, which is where exactly the justification comes from the groom's side for a situation of dowry. Now, the act, to summarize what we did in the last few minutes, the Dowry Prohibition Act of 1961 penalizes both the giving and taking of dowry. That is a point to be noted. The idea behind penalizing both the giving and taking of dowry is to ensure that there is no facilitation for giving or promoting the cause of dowry by few brides' sides. A demand for dowry may be either direct or indirect. Section 304B of the Indian Penal Code punishes dowry death. Along with Section 304B, Section 113B was introduced into the Indian Evidence Act via an amendment for the purpose of facilitating the smooth prosecution of cases relating to dowry death. For proving dowry death, the first thing that needs to be proved is the existence of a demand for dowry. That would be all. Thank you.